NAGPRA is a human rights statute.
It is a process. It's a tool.
Level playing field and bring the ancestors back home.
It's about relationships.
NAGPRA is civil rights legislation.
NAGPRA itself outlines the expectation of tribes and museums.
A reconciliation.
That they were not collectibles, that they were not specimens, but they were ancestors of people who are alive now. In all ages, people have protected the sanctity of the dead. Disinterment of the dead is strongly disfavored under American common law. Yet, even though common law went to great lengths to protect the sanctity of the dead, it historically failed to protect the graves and the dead of Native people.
At that point in American history, there was a loophole in the American laws and social policies that allowed the disparate treatment of Native dead.
The practice was so widespread that virtually every Indian tribe or Native group in the country has been affected by non-Indian grave looting. As railroads moved west in the 19th century and opened vast areas of land to non-Indians, looting of Indian grave sites became commonplace. After 1906, the United States government, as part of its land management function, issued permits under the Antiquities Act of 1906 and later the Archaeological Resources Protection Act of 1979 to provide archaeologists with access to cultural sites on federal and Indian lands. Most excavations involved Native American burial and habitation sites. It did not involve the descendant communities in the permit decisions. Human remains and items removed from graves in Indian communities were treated as openly available booty to be held in laboratory boxes and museum shelves as though they represented an extinct population. The dominant culture did not stop to ask permission before items were removed. When tribes did speak up, they found the courts were not available to them as a means to seek basic human rights or property rights. Part of the white man's conquering of the Indian has been dominance over their dead, and through the collection of objects of great spiritual and cultural meaning to tribes, which were treated as collectible antiquities by people who were either unaware of or did not care about the decimation of culture that resulted from such actions. Repatriation in Native Americans involves a wide array of complex and sometimes competing social interests, including human rights, race relations, religion, science, education, ethics, and law.
For many archaeologists, they never really thought about the contemporary populations whose cultures created the archaeological material they study. Many biological archaeologists as well weren't really concerned because they didn't have to think about the impact on contemporary populations.
I think there was a perception based upon, century or more within large segments of the museum and scientific community that these were really their items to collect, to study, to display. To deal with this topic, to effectuate a sea change in the ethics of both personal collecting and acquisition for the purposes of education, it is necessary to understand this history. Because the courts failed to act and recognize the right of tribes to seek the return of their ancestral remains and cultural objects, it became necessary for Congress to act and devise a law that would change the social ethic. The goal was to cure the effects of decades, even centuries, of irresponsible and exploitive actions toward Native Americans. In going forward, it is important for those involved now, in federal agencies and museums, to work with tribes in the spirit of healing that underlies this change in federal law.
There's a little bit of a shift in terms of how institutions work with Native tribes and basically are coming to the tribes to say, what is the story that you want us to tell? There's a lot more involvement, and that has never been the case, not always at least.
On November 16, 1990, the Native American Graves Protection and Repatriation Act, or NAGPRA, became law. NAGPRA represented fundamental changes in basic social attitudes toward Native peoples and their relationship with the museum and scientific communities and the public at large. NAGPRA culminated decades of struggle by Native American tribal governments and people to protect against grave desecration, to repatriate thousands of dead relatives or ancestors, and to retrieve stolen or improperly acquired religious and cultural property and return it back to Native owners.
And so what NAGPRA did is level the playing field. It provided Native Hawaiians, Alaska Natives, and Native Americans with equal protection of the law.
NAGPRA was part of a larger movement to recognize and rectify government actions taking place over centuries that had the goal of destroying Native religions and cultures. For most of American history, the United States government actively discouraged and even outlawed the exercise of traditional Indian cultures and religions. For decades, the federal government actually outlawed the sun dance, similar dances, and religious ceremonies and the practices of medicine men. It wasn't until the 1970s that Congress enacted the American Indian Religious Freedom Act. Although not enforceable in court, it did establish a federal policy to protect and preserve the right of Native Americans to believe, express, and exercise their traditional religions, including access to sites, use and possession of sacred objects, and the freedom to worship through ceremonies and traditional rites. In the late 1980s and 1990s, an effort was made by Indian tribes and national Indian organizations, with the support of traditional practitioners, to put teeth into this policy, to protect sacred sites and burial sites and the use of ceremonial objects such as eagle feathers, and to repatriate human remains, funerary, and sacred objects. These efforts were partially successful. A federal law was passed protecting the ceremonial use of peyote, and the National Historic Preservation Act was amended to recognize traditional cultural places as eligible for the National Register of Historic Places and mandating tribal consultation in regard to these places. Several states passed repatriation statutes before NAGPRA. In 1989, Kansas passed legislation concerning a reburial agreement between state officials, the owner of Salina Indian Burial Tourist Attraction, and 3 Indian tribes.
I got involved in repatriation work first in the mid-'80s when I received a call to come to Kansas to the Haskell Indian University to participate in a symposium about the Salina Indian Burial Pit. And as it turned out, that tourist attraction had on display several hundred Indian remains, which were of my own ancestors of maybe 600 years ago. And the only living descendants were the Pawnee, the Wichita, and the Arikara people. And so I ultimately got involved in representing those tribes to seek legislation in Kansas to rebury those dead.
An example of how the American court system failed to protect basic tribal property rights can be seen in the case of the Iroquois Wampum Belts. A court case was brought in 1896 where the tribe sought to have the wampum belts returned based upon conventional theories of property law, conversion, and removal without permission. The case was unsuccessful. The Iroquois never gave up, however. The dispute was ultimately resolved not by court action, but by the museum reviewing its own actions in receiving and holding the belts and coming to an agreement after consultation with the tribes.
We began the effort to repatriate those large belts, were the foundation of the Haudenosaunee, the Six Nation Iroquois. Some of those belts, we don't know how old they are, but from the beginning.
Wampum belts are clamshell beads woven into strings and then fashioned into belts. And the way in which that's done tells stories or contains important historical information. So they're memory joggers, they're mnemonic devices. Through a series of events around the turn of the 20th century, it happened that these 12 belts ultimately ended up in the care of the New York State Museum. And the Iroquois Confederacy leaders, the Haudenosaunee Grand Council, had been trying for decades, really, to work out an arrangement to see them returned.
During the same period that individual states started to enact legislation to ensure the appropriate treatment of Indian human remains, the federal government, at the urging of Indian tribes and national organizations, also began to seriously consider the need for uniform national legislation addressing this issue. Between 1986 and 1990, a number of bills were introduced in the 99th, 100th, and 101st Congress to develop legislation that would directly require repatriation of human remains and cultural artifacts and protect burial sites. As the repatriation struggle became protracted and reached the federal level, it became a test for our country's commitment to its underlying values and to our American sense of social justice. The enactment of NAGPRA, however, was perhaps the most significant accomplishment that arose as a result of this effort. Although there are many strands that eventually came together and culminated in the enactment of NAGPRA, two of the most significant events preceding NAGPRA were the enactment of the National Museum of the American Indian, or NMAI Act, and the dialogue between museums, scientists, and tribes at the Heard Museum in Arizona. When the creation of a national museum began to be discussed, a number of Indian leaders and traditional practitioners began to raise the issue of these bones and the need for the Smithsonian to repatriate them. At hearings on the bill, and privately with the Smithsonian, the importance of including repatriation provisions in the NMAI bill was emphasized. When the NMAI bill, enacted in November 1989, included a repatriation provision, this was a clear message to the larger community of scientists, museums, and federal agencies that a comprehensive bill would be next. The momentum from the passage of the NMAI bill was critical to the passage of NAGPRA.
Prior to the enactment of NAGPRA, the National Museum of the American Indian Act was enacted into law, and that had repatriation provisions which were, in essence, the precursors of the NAGPRA law, providing authority for the repatriation of human remains and other cultural items that were held by the Smithsonian Institution.
The bills had been introduced, and as I mentioned, there were two factors that sort of paved the way for it. The National Museum of the American Indian Act, which required the Smithsonian to repatriate human remains, which established a precedent for a national standard to the rest of the federal government and federally funded museums and universities. And then this one-year dialogue that Senator McCain had sponsored, which had sort of been of the culmination of all of these bills that had been introduced since 1986.
Senators Inouye and McCain also strongly encouraged all interested to find a way to reach agreement on these issues. Largely as a result, a year-long dialogue took place at the Heard Museum in Arizona that centered around the appropriate treatment of human remains and cultural artifacts. Representatives from museums, scientific organizations, and Native American groups sat down at the table together and produced a document that provided a framework for NAGPRA. The report of the Panel for a National Dialogue on Museum Native American Relations contained consensus recommendations that provided an important framework for NAGPRA.
The American Association of Museums had launched an effort that was led by Michael Fox, who was then director of the Heard Museum in Arizona, myself, a lot of other museum directors across the country, and many tribal leaders and individuals that were involved in helping push for passage of some kind of repatriation legislation. And that was a very valuable process in that it brought people together face to face rather than dealing in the context of legislative actions or reactions. And for a number of folks, I think, in the museum community, for the first time really opened some major questions about the ethics involved in repatriation issues, and particularly with respect to Native American human remains.
About the same time, the movement was afoot in Congress to fashion some sort of national law dealing with repatriation, because voices from all over the country, from Indian people, from traditional people, were getting more emphatic about the need to bring back the ancestors, bury them, bring back the ceremonial objects, and reuse them again if that was the appropriate thing to do.
Still, many of the details needed to be worked out. The interested parties could be described as fitting into three groups: tribes, museums, and archaeological associations. Each met in their own caucuses, and there was much interaction and negotiation between tribes and the museums and archaeologists concerning the exact language of the final bill. The staffs of Senator Inouye and McCain and Congressman Udall were also very engaged in this process. It was exciting. I mean, you just, there was so much activity around this, constantly trying to work this through. There were so many people trying to get this done, and we were running out of time. That particular year, I mean, we were very fortunate because usually Congress would adjourn in the middle of October. And that particular year, there was some tax dispute that the first President Bush was having with Congress. And so Congress stayed in session much later than it ever did any other time.
And I would say that there was a sense of unease as these issues were approached initially, as the proposal to expand the scope and application of the bill that was initially intended to apply only to federal agencies was proposed, and museums and scientific institutions realized that they were going to be drawn into the fold, if you will, of this bill. There was a concern expressed that if there wasn't some constraint or restraint on the part of Native communities across the United States in their desire to repatriate human remains and cultural items, that the great, and this was a quote, and it was said many times, that the great museums and scientific institutions would be emptied of their Native American collections, and they would be left with nothing. So there was that specter that defined one end of the spectrum, if you will, of viewpoints.
Fundamentally, I think for some of us, we reached a point at which we had to make a decision about what was ethically right versus what might be responsive to the then internal politics of the museum community or some components of it.
The give and take ultimately resulted in some compromises. One involved the concept of cultural affiliation, which is required for tribes to repatriate human remains and cultural items. Cultural affiliation was defined to include tribes with a shared group identity with the remains or items. This determination is based upon an overall evaluation of the totality of the circumstances. The standard does not require scientific certainty, nor an unbroken history to be established in order to have a successful claim. An early version of the law required establishment of continuity of group identity from the earlier to the present-day group. This phrase was deleted from the law.
The NAGPRA standard for determining affiliation pulls in all of these different lines of evidence, from very scientific, physical anthropology, archaeology, geography, but also oral history and religion. And these different lines of evidence are all weighed equally when we make a decision on disposition under NAGPRA. And I think that all of those other lines of evidence that perhaps in the museum or archaeological world weren't weighed heavily before, such as oral history, now have a much higher weight perhaps than they did before in anthropology and archaeology, which leads to a much better understanding, I think, of Native American cultures and lifeways.
Compromise language was also developed for the definition of sacred objects. Not all objects that could be considered to be sacred by a tribe are covered by the law. Rather, a precise definition was crafted based upon the need of objects for use by current-day ceremonial practitioners. Although this language limited the scope of the definition in one respect, it also placed the decision about what is needed in the hands of the traditional practitioners of each tribe.
I recall that a particularly thorny issue was the concern that if the term sacred and what was sacred to any particular tribe or to a Native community was to be defined by that community, how could those from whom the repatriation would take place, a museum or scientific institution, how could they be assured that what was sacred to a Native community was part of their core belief system and not something that the community would describe as sacred for purposes of seeking repatriation, even though that object might not be central to their cultural practices or religious beliefs.
Certain aspects of the law were thought to be so complex that they were reserved for future action. For example, the issue of how to handle the human remains for whom cultural affiliation could not be determined, the culturally unidentifiable, was expressly assigned in the law to the Review Committee. The Review Committee would consult on this topic with tribes and museums and scientific organizations, and then make recommendations to the Secretary for a process for disposition of the culturally unidentifiable. Although the bill that was enacted reflected a compromise forged by representatives of the museum, scientific, and Indian communities, it was designed to protect the essential human rights of Native Americans and was specifically based upon the special relationship between the federal government and Indian tribes. Congress believed that NAGPRA would encourage a continuing dialogue between museums and Indian tribes and Native Hawaiian organizations and promote greater understanding between the groups. After all the compromises and flurry of statesmanship, the final vote on the bill came with not one vote of dissent in either chamber. The law was signed into place as a fully bipartisan piece of legislation. All of those involved in its development urged signature. It was a time of coming together for tribes, museums, and scientific organizations to do the right thing. NAGPRA is unique legislation because it is the first time that the federal government and non-Indian institutions must consider what is sacred from an Indian perspective. To accomplish that, the law built consultation with the indigenous community into the process. The law provides the legal standards, framework, and the process, but the actual results relies largely upon those with first-hand knowledge, the tribes and Native Hawaiian organizations. NAGPRA is a law that has served as an example to the world and as a catalyst for other countries to address these fundamental issues of human dignity. NAGPRA is not a punitive law or one of retribution. Rather, it is designed to foster healing.
But the spirit of NAGPRA is to bring together the museums, the federal agencies, and the tribes in long-term partnerships.
There is a recognition, a national recognition, that there are particular items that are so integral to the survival, the continuing survival of a people. And I think the NAGPRA law actually sort of tries to capture that spirit.
When there is inclusion of the tribes in the process, in consultation, the eventual decisions made are predicated on a richness of knowledge and with a sensitivity to living, vibrant cultures that cannot be derived solely from the archaeological record. NAGPRA has established not only a process for handling human remains and cultural items in collections and new finds on the land, it has established a new protocol for dealing with diverse communities as necessary players in the process. It is, as Senator Inouye proclaimed, human rights law.
I am happily surprised over the past years at the relationship that has evolved between many museums and many tribes. It's not universal, but I think what has happened is that a number of tribes have been, and traditional people have been surprised in a good way to find out that their traditional ways of life are being preserved and have been preserved through the collections that are in museums.
From my perspective, NAGPRA has brought indigenous knowledge into the museum world. Conversely, Native Americans have been more familiar, or they've become more familiar, with the knowledge and scholarship of museums and academia.
There are several ways that I think NAGPRA has actually enhanced the relationship between federal land managing agencies and Indian tribes, Alaska Native villages, and Native Hawaiian organizations. The first is, as I mentioned, the fact that the statute has empowered tribes in ways that they weren't previously, even under the National Historic Preservation Act, in that they now know that they have a right to be at the table, an expectation that they'll be consulted when there's a possibility that material of cultural importance to them might be encountered through some federal project.
From my perspective, NAGPRA constitutes a fundamental shift in the relationship between museums and Native American communities. It's rearranged the power dynamics. It's opened up museums and their collections it's created dialogues and exchanges in ways that were relatively uncommon before 1990. And from my perspective, although NAGPRA is not perfect, and there's parts that certainly could be improved upon, and there's a lot that does work, that really, at the end of the day, it's been a sea change for museums.
Every museum has a mission, and a museum has a mission to preserve and protect collections, and sometimes study collections. And what does that mean? It's to raise awareness and educational of their collections to the general public. For us, a federal law, NAGPRA, came into effect that allowed us to bring some of the remains home, bring some of the objects home, sacred objects, objects of cultural patrimony. And to me, it's very important that you understand on both ways, like what I was saying, the collection itself might have a value of national significance. How is that going to have an impact on the educational value of what a museum is supposed to do for the public? How is that mission going to be affected? And how are these collections being returned home to us? How is that going to affect our community? How is that going to affect our people? All of these things have to be considered and before you make any kind of decisions on final disposition of those collections.
But also, it's opened a door for us to be able to create a common ground with those institutions. Because one thing I like to explain to our people at home, our Native people, is that you have to understand that these non-Indian people that work for these institutions have that same love that we have for our ancestors and for our remains, but it's coming from a place that they understand. And we're coming from our place, and we need to realize that we both care for those remains, but it's in very different ways. And there's a way to be able to mitigate that and to figure out what would be best for everyone.
A law that represents a major sea change in the ethics of dealing with tribes, their dead, and respect for their cultural items could not be expected to play out quickly without bumps and some confusion. However, in the 20 years since the law's passage, museums and federal agencies have increasingly begun to work with tribes in all areas of their domain that should or could involve tribes. Standard operating procedure is slowly changing to include tribes as a matter of course. This was one of the goals of NAGPRA. Those museums and federal agencies that have accepted the law and moved forward to work through the process report enhanced knowledge of tribal cultures, enhanced education in museums, and better working relationships in all aspects of federal land management. The importance of NAGPRA is as great today as it was 20 years ago. Passing the law was a huge accomplishment, but ultimately implementing it is even more important.
The most valuable lesson I learned was actually twofold. One was, I think, the spiritual power of our ancestors, who, in my view, guided many of our efforts at that time as we went into the halls of Congress. And the other lesson that I felt was instructive to me was that Americans are fundamentally a fair people, and that once they are informed about a problem and given the facts at hand, they more often than not act to do the right thing. And this was certainly the case with the NAGPRA law.
I guess I want to say thank you to Congress for giving us NAGPRA. And I say it in a weird way, because I say it laughing like that, because there is criticism in Indian country of NAGPRA. But and although I will sit here and tell you about the 123,000 sets of ancestral remains that haven't come home and this work that needs to be done, I can also tell you about, the other sets of remains that have come home. And so, and setting this process into place.
I think it's humbled me a lot because I had a lot of assumptions about what I thought I knew as an archaeologist and as a scientist and as a woman. And it has humbled me. I've been privileged to take part in events that I never would have imagined taking part in. And I've built some deep, lasting friendships, and it's really helped me to gain empathy for understanding belief systems that are not my own. And that's what's really, I think, important in a struggle with this, is that I've heard so many times people say, well, what's the big deal? If it were my grandmother, I wouldn't care. Well, the big deal is it's not your grandmother, it's someone else's grandmother, and they do care, you know? And so I think building empathy and cross-cultural understanding has been pretty pivotal for me.
The last reburial I did was January. We just got the remains back. It was from a disposition. And I was like, oh man, I don't want to have these hanging out in my office all winter, you know? So I got my snowshoes on and threw them on my back, you know, and I had this shovel and I was like trekking through the woods, and it's like, I hope the ground's unfroze. If not, I'm gonna have to start a fire. But luckily I started digging and the ground was unfrozen. You know, it's just like cool, you know, you feel really good. You know, you're reburying, and the remains were all kids, you know, just like little itty bitty skulls and just little guys, you know, and they're from right down where I grew up in Mackinac City, which is like 20 miles from Cross Village. So this is like real personal. And it's like felt really good, you know, it's like I did something good today. You know, it's just like something I can be proud of. I call my mom and she's all happy and tell other people. I was like, oh, that's a good thing.